for that kind introduction. And I begin by acknowledging the first Australians on whose land we meet and whose cultures we celebrate as the oldest continuing cultures in human history. To those of you who are guests from around the world, welcome to Australia. And for those of you who are guests from other far-flung states of our glorious Commonwealth, welcome to Sydney. For those of you who have come from Queensland this morning, I welcome myself as well. Also to our distinguished representatives from China. I appreciate the fact that you have travelled here for this conference. I've also seen where you all come from. We have delegates here from 中国人民大学, we have Shanghai 大学, we have 吉林大学, 华东大学, 清华大学, 中南财经政法大学, 东南浙江, 苏州, 北京, 对外经贸大学, 沿海大学, 南京大学, 山西大学, 南京大学, 华东大学, 南开大学, 中国政法大学, 各类大学都在，十分欢迎我们中国来的朋友。It's an impressive representation from our friends from China. As has just been noted, the extraordinary advances in China's legal education, which have been achieved over the last 30 years. I first went to live in China about 30 years ago. I saw the aftermath of the Cultural Revolution. I saw the very thin opportunities for students of law in those days. And these have been very significant advances. Those of us who know China and who like China and who have spent a lot of time in China, as I do, will appreciate how far China has travelled, and also China's recognition itself of how far it still has to travel in the future. I was a bit puzzled to receive this invitation to open this conference. As has been delicately and diplomatically noted, en passant, I've never studied a day of law in my life. The only skill I bring to the table is a degree in classical Chinese poetry. And that has so far not constituted a radical career impediment. But even when it comes to my Chinese language skills, it can get you into all sorts of trouble. I recently, as some of you may have read in the newspapers, have become a grandfather. So our daughter Jessica and her Chinese husband Albert have produced our first Wai Sun Yu, our granddaughter. And so I'm also very engaged in the Chinese and Australian social media. On Twitter, I'm actively engaged in the Chinese equivalent, which is called Xinlang Weibo or Tongxin Weibo. I also have a lot of Shui Fensi, which is followers. So I dutifully on Weibo announced 2 days ago that we were celebrating on Saturday in Brisbane the baptism of our new daughter, granddaughter I should say, and mindful of Chinese regional variations, I thought I'd prove how clever I was. In the north of the country, to refer yourself as a maternal grandfather, the safest expression is as a laoye. So I signed my Twitter, Lu Laoye, which is grandfather Lu, or in my case, right. Then in brackets I put B, which means for the north. And then after that, knowing that in the south I had a different word for a maternal grandfather, I signed it Lu Gong Gong. Now this creates a particular problem because in Hong Kong, Gong Gong is often used a lot. Except in the north of the country, if you refer to yourself as a Gong Gong, you're not a maternal grandfather, you're a eunuch. This creates, obviously, a certain contradiction. This has led to a very long debate in the Chinese Twitter sphere in the last 4 years about my competence in the Chinese language. But what is interesting is that China is so vast, is that all the southerners in Hong Kong and Guangdong attacked all the northerners for attacking me because of the use of which they find perfectly acceptable. So the compromise is that I should use the word Wai Gong and not Gong Gong. So that has now been resolved in the Chinese sphere. in the great democracy of the contemporary social media. 500,000 Chinese followers have participated in one way or another in this amusing debate, of which I have been the largest casualty. My remarks to you today are essentially threefold. Firstly, a statement of the obvious, but nonetheless the important, and that is that globalisation now affects everything that we do in every sphere of what we do. The second argument is that because in Asia we find the fulcrum of the globalisation of the 21st century, driven by the major economies of Asia and driven within them by China itself, there is, I believe, a large opportunity for this country, Australia, as the Western country in Asia, to become a greater and greater repository of the knowledge of Asian law and the knowledge of Chinese law in particular. My third argument, beyond all of that, is in the realm of international public law, where we have had many controversial debates in recent decades. There is a wider argument for Australia's engagement as well in the unfolding doctrines of international humanitarian law, and most controversially in the area of the responsibility to protect. So I will seek to address those three themes briefly in my opening remarks. Firstly, on globalisation itself. We are at the crossroads of a phenomenal change in human history. The international relations scholars have described it for a long, long time as the collapse of the Great Divide. If you look at the Great Divide, international relations theory, it has always separated out the foreign from the domestic, the external from the internal, the international from the national. These are concepts which made a lot of sense in the 19th century. They made some sense in the first half of the 20th century. They have made less sense in the second half of the 20th century. They almost make no sense today when we see the globalisation of all things that we do. Of course, the fundamental tension here, given that reality of globalisation, is the continuing doctrine of the absolute sovereignty of states, which we have had since the days of the Treaty of Westphalia. Let's look at a most current and recent example of where this becomes fundamental to us all, and that's the global financial crisis. There you see the evidence of the globalisation of economic and financial activity to the point that it affects all states, it affects all economies, it affects even the financial viability of an individual university, it affects the number of students who will travel from abroad to study at this university, the fees flowing to the Faculty of Law at this university, and therefore the viability of continued international education as well. Therefore, when you look at something like the global financial crisis and the fact that the volumes of global capital and the volumes of global capital which are traded in national and international environments vastly exceed the capacity of a single nation state to regulate those flows, you are automatically put in a position where you have to engage in forms of global economic and financial governance which had not been thought of in previous decades and certainly in previous centuries. It is not just, however, the globalisation of economic and financial transactions that we are talking about, where the sheer volumes of globally mobile capital defy the absolute sovereignty of states to regulate them. We are also talking about the globalisation of security, of which the most obvious example is the impact of terrorism on multiple states. We are talking about the globalisation also of our concerns with the movement of peoples around the world in increasingly large numbers, involving every branch of law, whether it is purely migration law, through to individual criminal legal matters, through to the whole question of regulation of the transmission of globally infectious diseases. This, in quantitative terms, is a vastly new phenomenon. Therefore, the imperative it places on all forms of global cooperation is greater than it has ever been in human history. And that is dictated purely by the mathematics of the quantum of global engagement as opposed to the quantum of internal national engagement that we have seen when measured against previous periods in history. Mention has already been made of one simple illustration in terms of the domestic consumption of apples in this country. We've used a global dispute resolution mechanism available through the World Trade Organization, which in turn rests on a body of global trade law which has been decades in its evolution and still yet to be perfected. Nonetheless, my overall point to you is this: the structural dynamics of globalisation are now such in every field of human endeavour that not just the acts of political cooperation, but underpinning that the fabric of international legal engagement, both in public law and in private law and international commercial law, will become greater and greater and greater. The premium, therefore, which that places on your profession to become truly a global profession is therefore at its foremost. The second point I'd make about Asia itself is simply this: we are witnessing this huge global change driver, this huge global megatrend called globalisation itself, which is the volume of global transactions when measured against the volume of internal national transactions is changing radically. That is meshed with the fact that simultaneously we are seeing a great change also, a great mega change in the global distribution of power. Here, of course, it is referred to normally as the rise of Asia, and within the rise of Asia, the rise of China itself. Let us simply contemplate one core fact which should seize all of our attention. Sometime in the coming decade, most economists have concluded and agreed that China, by whichever measure, gross domestic product or purchasing parity pricing, will become the world's largest economy. Contemplate that fact for a moment. This will be the first time since George III that a non-Western, non-democracy will be the largest economy in the world. It is arguably the first time in 500 years since the Spanish Empire that a non-Western country has been the largest economy in the world. Therefore, this of itself is an historic event. And therefore, the challenge that we all face, our friends from China, our friends from the wider region and across the world, in ensuring that this change is managed peacefully, but also it is managed effectively in a stable manner, transactionally, including through the law, is a paramount challenge for us all. To state the obvious, China itself does not emerge from the tradition of Magna Carta. China itself has not been through the experience of the great political and legal reforms that we have seen in Europe, starting from the period of the rise of modern nation-states through to the Glorious Revolution, through to the various reforms of the 19th century, and the revolutions of 1830 and 1848, general emancipation of entire voting populations in the 20th century, including the rights of women to participate in the political process. China has not been party to that political evolution. It has not been party to that legal evolution, the evolution of basic concepts of rights and of human rights. Renquan is of a different traditional origin in our tradition to that which has been the case in China. That is not to say that rights, 权利 or 人权, do not exist in the Chinese tradition. They do. Any careful study of the Chinese classical literature will reveal that to be the case. It is, however, differently explained. But my overall point is this: as this large Chinese power becomes the largest economy in the world in this decade that we are living in now, and where you are teaching in your university now, we are now at the point where the rubber truly hits the road between different traditions of laws, conflicts of laws, and frankly, simply things being lost in translation. This creates, again, a premium on your profession to try and bring these two traditions together. But as a further point I would make also beyond China about the rise of Asia itself, it's as follows. If you project out over the next 20 to 25 years, it is not just China that we are speaking about, but more than 5 of the world's top 10 economies will come from our region. China, India, Japan, Indonesia, Korea. These will all be in the world's top 10 economies. And therefore the premium, not just to understand the unfolding phenomenon that is China itself, But the wider phenomenon of rising Asia is an imperative for those engaged in the teaching of law in this country, and dare I say it, across the collective West. Indonesia, for example, few people observe this fact. By the time we reach 2030, the projections are it will itself be the 7th largest economy in the world, and considerably larger than this one, Australia. And therefore, given that Indonesia is our neighbour, I would hate to ask the question in this room, who is an expert on Indonesian law? How many experts on Indonesian law do we have in this country? Indonesian commercial law, Indonesian criminal law, and the rest in terms of Indonesia's legal engagement with the rest of the world. These are imperatives which are facing us as well. Here in Australia, we are happy, in one respect, to be recipients of an intellectual and pedagogical tradition which comes out of the British, and in terms of the understanding of Asia, has been spawned in large part by the School of Oriental and African Studies in London. This institution has its impact in Australia in the teaching of Asia. I myself am a beneficiary of it, having studied at the Australian National University, which in the post-war period was fashioned on the traditions of SOAS in London. What does that mean in practice? It meant that in the establishment of the Australian National University and the broader teaching of Asia in this country, that we had a tradition whereby we simply did not teach the languages of modern Asia. We taught the languages of classical Asia. We also taught the civilizations of those languages, their histories, their politics, their economics, their culture, and their broader civilizational achievements. This is a good intellectual tradition. In other words, it sees the importance of Asia not simply in terms of the utilitarianism of the familiarity with modern language, but everything which sits underneath that as well. So that when you have a contemporary discourse in modern Chinese politics about, for example, what the term democracy minju means, then you automatically are bringing to the surface the understanding of those terms min and zhu throughout Chinese modern and classical traditions. Back to the days of Sun Yat-sen and Sun Yat-sen, back into the 19th century, back into the classical period as well. It is that level of understanding which helps us in the collective West and here in Australia as well understand where China's modern engagement has its own conceptual origins. But my point is this. Here in Australia, the teaching of Asia is under considerable duress. For reasons I do not understand, when our engagement with collective Asia is on the increase, the actual teaching of Asia is at best static in this country. It needs to be radically changed. My further point is that within that, the teaching of the emerging body of laws of the major economies and societies and polities of Asia becomes doubly important. If we were to aggregate in this room the experts in Australia in each of the national bodies of law in Asia, then it would be an interesting gathering to see how many would attend. We have to lift our collective game, and by that I mean the nation, not you individually as representatives of your individual faculties. Because I believe there is a unique opportunity for Australia, and it is this. We in Australia, as I said, are the Western country in Asia, together with our friends in New Zealand. Therefore, it follows that when the collective West looks for countries which have had to fashion their futures in Asia, as we have done this last half-century peacefully, with our friends next door in Indonesia, the largest Muslim country in the world, together with our friends in China, about to become the world's largest economy. The collective West will begin to look increasingly at countries like Australia in terms of how we fashion this long-term engagement. There is therefore a critical, to use the word already deployed, comparative advantage for Australia to harness the enormous capacity of national legal expertise that we have in directing that into a national resource, an international resource, the global go-to place for the understanding of the laws of Asia. That, I believe, is part and parcel of the vision which I described earlier on, both as Prime Minister and Foreign Minister in this country, of making sure that Australia was the most China-literate country in the collective West, but Australia was the most Asia-literate country in the collective West as well. And that includes the study of law. My final point goes beyond globalisation and the driving imperatives for you in the legal profession to provide, shall I say, the legal arteries through which that globalisation can be accommodated in all of its dimensions. To go beyond the point that I have just raised now about the particularities of China and wider Asia in what is the Asian century, to a final point concerning the great and controversial challenges of international public law and international humanitarian law today as well. Again, I think there is a role for this country, Australia, which is not at the margins. I've just spoken about Asia. We are the fourth largest economy in Asia, after Japan, after India, after China. Around the world, we are the 12th largest economy. We are members of every significant institution within Asia and the Pacific. We are members of the G20. We are founding members of the United Nations. We are active at every single UN institution and have been since the commencement. We are also founding members of other institutions such as the Commonwealth, which bring together countries from diverse regions, including Africa, the Caribbean and elsewhere. My overall point is this. We often lose sight of this within this country, but around the world we are seen as having international good officers that we can bring to bear in the great challenges that we face in the international community today. For these reasons, I've long argued that Australia is a middle power with global interests and with regional interests, and that we give effect to those global interests and regional interests through what I describe as creative middle power diplomacy, and that in executing that creative middle power diplomacy, one of its principles is good international citizenship. That in turn is about the construction of a robust, reliable, rules-based order, not just for Asia and the Pacific, but more broadly across the world. An international rules-based order. The international community has achieved much progress on this since the foundation of the United Nations in 1945. If you compare the order that we have today compared with the order which pre-existed, pre-39, any historian will lead you to conclude that great progress has been achieved. The nature of contemporary politics is we always point out that which we have failed in, rather than equally recognise where the successes have been realised. And they have been formidable. One of those areas is the body of international humanitarian law. And this again is where Australia's good officers and our international legal expertise has been brought to bear as well. Of course, this is a long history. You're familiar with it, those of you who are expert in the field. But from the beginnings of the emergence of the discussions following the Second World War, the Fourth Geneva Protocol on the protection of civilians, through to the Refugees Convention in the 1950s, through to the great debates in more recent decades which led to the formation of the International Criminal Court, leading in turn to further debates and resolutions by the international community around this concept of the responsibility to protect. These are all controversial areas. But if we look at the enormous tragedies that we have seen in the last couple of decades in crimes against humanity, war crimes, and the rest, and crimes of ethnic cleansing and crimes of genocide, and we look at what has unfolded in Somalia, we look at what unfolded in Rwanda, we look at what unfolded in this decade just past in Darfur, and how the international community was by and large silent as atrocities unfolded in Bosnia and then later in Kosovo. What the international community is a product of these single and singular failures of the international legal system have done is evolved these new and emerging doctrines of international humanitarian intervention. Of course, we saw application most recently in the great debates concerning Libya. People now say, well, the Libyan intervention may have gone too far. I would ask those who doubt that and raise those possibilities to ponder this question. Had the international community not acted when it did in bringing about a UN Security Council resolution which permitted a no-fly zone over Libya to protect the people of Libya, at a time when Gaddafi's troops were moving down to Benghazi, a city of almost 1 million people, which was the home of the anti-Gaddafi revolution, then right now what we'd be debating in this conference now would be the failure of the international community to have prevented the butchery of Benghazi. That's what we would be discussing. That's what we'd be debating. Instead, the international community resolved to act. I'm proud of the fact that as Foreign Minister, I led international foreign ministerial calls for that action to occur, prior to being fashionable to do so. It was important because it represented a single opportunity to learn from the listed failures I referred to before. And so too, we confront the next challenge, which is Syria. I do not believe it is right for the responsibility to protect, as underpinned by the agreement of international heads of government in 2005, to push to one side permanently the possibility of using the coercive powers available to the United Nations Security Council to act also in Libya, in Syria as well. Of course, under the responsibility to protect and the resolution of 2005, there are multiple mechanisms available. Not all of them coercive, but there are a number which are non-coercive, and what is referred to as the three pillars of international humanitarian legal intervention. And humanitarian intervention, both diplomatic, military, and in other forms. But my overall point is this evolving body of international humanitarian law is important in us as Australians prosecuting a policy of global good citizenship, of us prosecuting a policy on behalf of Australia which seeks to build an international, global and regional rules-based order, including in the humanitarian domain. And we in Australia, and you in the international public legal professions of this country, also have an opportunity to contribute to a greater Australian voice in so doing. I believe it's part and parcel of who we are as Australians as well, giving effect globally to values which we hold deeply here domestically. The controversies associated with this I'm well familiar with, and there have been a body, in fact an avalanche of academic literature written on it. But against the basic moral judgment that is the world a better place for those interventions having occurred, rather than hiding behind an absolute doctrine of state sovereignty and saying that Libya should be left to its own devices, I think the conclusion on behalf of us all would, I believe, be clear. To conclude, therefore, these are important areas for your profession. Globalisation inevitably pushes us in this direction. Asia and the Pacific, and China in particular, represent massive opportunities and massive challenges for your profession, which is why it is so good that we have so many representatives of the Chinese legal teaching profession here with us in Australia for this particular conference. But more broadly, I believe all women and men of goodwill and nations of goodwill must continue to throw their full intellectual and political efforts at the emerging task of ensuring that the body and the practice of international humanitarian law indeed prevents further atrocities on a mass scale from occurring in the future. With those opening remarks, I congratulate you as teachers in this important profession, and I have not darkened a single one of your classrooms ever. But my two oldest children have, and now are both qualified lawyers and have both been admitted. But I do say and emphasise, as someone who's been in this field of international diplomacy for some time, the work you do is not a barren academic legal enterprise. It is one which is quite fundamental to ensuring that we as Australia play our part in building an international, global and regional rules-based order for the future.